Hello friends, this is PP and welcome to Law for All. In this video, we're going to be learning how to draft a civil suit in India. Now, considering the increase in litigation in the Indian courts these days, it is very important to know how to effectively draft a civil suit. And furthermore, it is all the more important to know as to how to word specifically a civil suit, because of which now we would be required to know the exact contents of how to draft a civil suit. Now, proceeding further, in a civil suit, getting started, there are some of the important things that are required to be kept in mind while drafting a civil suit in India. First and foremost, the draftsman has to have good grasp of legal jargon and terminology. That is, a person who is drafting a suit has to know the proper legal jargon, proper legal words, the words that are to be used in a civil suit. Excuse me. And further, a perfect terminology, because a legal word can be substituted for a long sentence. Legal dictionary has already provided for certain specific words which make the suit, which give specific meanings to the context in which the words are used, and so therefore it makes the suit all the more effective and all the more proper. So therefore, good grasp of legal jargon, that is legal terminology, is an absolute must if one wants to draft a civil suit properly. Furthermore, sound knowledge of applicable laws is also very important, because when one is drafting a civil suit, you have to know the laws which are properly applicable to the civil suit, because otherwise, if a suit is barred by law of limitation, or there is something which is explicitly barred or explicitly not permitted in a specific law, then that has to be kept in mind, and accordingly suit would have to be drafted. So therefore, ignorance or no knowledge of specific laws which pertain to which are applicable directly to a civil suit, if those laws are not kept in mind specifically, then it can have adverse effect over the entire suit, and which can eventually lead to the suit failing altogether. So therefore, that is one factor which has to be kept in mind. Furthermore, the entire suit should be previously thought over. That is, before a draftsman starts drafting a suit, one has to imagine in one's mind as to how the suit is going to be, and what it is that exactly is eventually going to be prayed for. Accordingly, the suit would have to be drafted. The contents would have to be, the pleadings would have to be made. The pleadings, of course, will have to be specific. They have to have specific words, and the pleadings are eventually what make the suit. So therefore, the entire suit has to be previously carefully thought over, and only then a rough chart of the same would have to be made, and only then finally the suit should be drafted. Now, suit should always contain evidence. That is, one should carefully consider all the evidences available before drafting before drafting of the suit commences, because an evidence is the basis on which the contents of the pleadings are going to be proved. So therefore, evidence has to be kept in mind, and only then the drafting of the suit is to commence. Now, getting to the actual drafting of the plaint can be divided into three following parts, namely the heading, the body, and the relief. Now, these are the three most important parts, or rather the parts on which impetus would have to be laid by a draftsman before a draftsman starts drafting a suit. Now, let's get to the first one, the heading. The heading is the cause title of the plaint, and the same is mandated in Order 7, Rule 1A of the Code of Civil Procedure Code. The heading is essentially the cause title, in the sense that it contains the title, that is the court in which it is filed, the name of the parties, etc. Now, the heading states the name of the court in which the plaint is to be filed, that is, in the Court of Civil Justice Junior Division, or in the Court of the District Judge, or in the Court of the Additional Director, or anything of that sort. So, the heading always has to begin with the court in which the plaint is to be filed. Proceeding further, the heading also has to contain the regular civil suit number, that is the suit, if it's a suit, then the suit number; if it's an appeal, then an appeal number, or any specific nomenclature which is used by the court for addressing a specific suit. Now, furthermore, uh, the heading has to contain the name of the party specifically, that is the plaintiff as well as the defendant. They have to be added carefully and properly and systematically. If the defendant is a performer party, then that performer party should always be added at the last. The important parties, primary parties, should always be added first. Their addresses would have to be stated comprehensively and correctly so that they can clearly be identified. Their names, the name of their fathers, or the name of their husbands, if in the case of a woman, as the case may be, their age, their address, their occupation, their marital status, all of which would have to be specifically stated in order to identify that person specifically, so as to avoid any ambiguity subsequently. Furthermore, it should also contain the nomenclature, that is, a suit for recovery of money, or a suit for specific relief, a suit for mandatory injunction, and so on and so forth. Because the nomenclature is necessary, because for the first glance itself, it becomes easier to understand what the suit is about. Furthermore, it should also contain the provision under which it is filed, that is, a suit under Section 9 of the Civil Procedure Code, or a suit under Section 34 of the Specific Relief Act for declaration, and so on. So, therefore, it has to contain a specific provision under which it is filed. Otherwise, now, as under the new registration system of civil suits, as far as I understand, the provision is stating a provision is specifically mandated. Otherwise, the suits are not entertained. So, therefore, provisions will have to be specifically stated as well. A suit plaint should always contain the phrase "May it please your honor." If this phrase is not present, then the plaint can also always get rejected. So, therefore, this statement is always an absolute must in every plaint, and of course it respectively applies in every language that the suit is filed. So, like for example, if the suit is to be filed in a vernacular language, for that matter in Hindi, because in some states it is so entertained, in that case an equivalent statement would have to be made. But if it is in English, "May it please your honor" or may it please this honorable authority," it should always be stated. The body of the suit. Now, coming to the body of the suit, the body of the suit is the most important part of the plaint. Now, the body of the suit contains the pleadings. That is, the body of the suit contains the introduction, it contains all the details as regards the suit, it explains the entire suit, it explains all the facts, it makes references to documents. So, therefore, the body of the suit is the most important part of the suit, and care is to be taken in drafting the body, the pleading specifically and properly. All the facts in the body, that is, as regards the suit, will have to be stated in the body, and they have to be specific and they have to be clearly stated so as to avoid any ambiguity. Because the more comprehensive and the more coherent your suit is, the better it is for the judge as well as the opposite parties to understand, and thereby increasing your chances of succeeding in the suit. Pleadings should always state facts and never the evidence. In the body, pleadings are to be stated. Pleadings are specifically to be made, and they should always state facts and never the evidence. Because suit is always subject to being proved, so evidence comes subsequently. But suit should always only contain facts. The body should contain specific clauses as regards the cause of action, payment of court fees, statement as regards suits following the period of limitation, etc. All these clauses are mandated, strictly mandated by law, and the same would have to be strictly adhered to. And if in the event they are not adhered to, then the registry of the court simply refuses to register the suit. So the body needs to contain all of these specific clauses. The body also needs to contain specific statement as regards how the court has jurisdiction to entertain the suit. That is, if the suit is falling within the pecuniary jurisdiction of the court, or if it is falling within the territorial jurisdiction of the court, all of the same would have to be stated. The cause of action also is required to be stated, because that eventually determines the jurisdiction of the court. So that is another factor that is to be considered. Finally, coming to the third part, the relief that is to be paid in a civil suit. Now, the relief contains the prayers in the suit. Relief is essentially where the prayers are made. That is, for a decree of mandatory injunction, or for a decree of recovery of money, and so on and so forth. That is the eventual relief that is prayed for in a civil suit. Now, the relief that are paid for in the prayer clause have to be thoroughly comprehensive, and any ambiguity in this release should be clearly avoided. Because if there is any ambiguity while filing execution, while even if once and if the decree is obtained, for the purpose of filing and execution, it becomes a little difficult for the court to interpret if the prayer clause itself is ambiguous. So therefore, the prayer has to be carefully thought over. It has to be seen whether the prayer is tenable, whether if such a prayer can be granted, and whether if in the event the prayer is granted, that it will be specifically executable. So that is another very important factor that will have to be considered. Now finally, the valuation of the suit also has to be kept in mind while making the prayers, because the prayers eventually determine the valuation. So if in case a recovery of money is sought, and if a specific amount is quoted, the court fee will depend upon the amount that is quoted. The higher the amount that is quoted for recovery, the higher the court fee that will be required to be paid. So therefore, accordingly, the same will have to be kept in mind. Release should always contain a prayer for costs also, because every time a suit is filed, the plaintiff is always entitled to costs. So therefore, a specific prayer as regards payment of or grant of cost should be made in a civil suit. And it should also be kept in mind that courts are not always bound by only the prayers that are made in the suit, but the court is also entitled to go beyond the prayers and grant reliefs or make such orders as may be deemed fit and necessary. So therefore, while drafting prayers in the relief clause, care should also be taken to state that the court may grant any order fit and necessary, because in the event subsequently the prayers become untenable, then the court will always be in a position to grant any other prayer which is deemed fit and necessary. Finally, links to a book which explains the concept comprehensively, which further contains model forms of civil suits commonly filed in India, is also placed in the description section below. So you are free to check it out. It might be of some help to you. Kindly consider liking, sharing, and subscribing this video for more such awesome content. Thank you for watching.